Good morning, everyone. Welcome. Our first case for argument this morning is Ted Veloff versus the Cook County Sheriff. Mr. Flaxman, good morning.
Good morning, Your Honor. May it please the Court. This case involves prisoner property. The Court has ruled on at least 3 other cases that involve prisoner property. This case is different. This case, the Court should find in favor of the prisoners rather than in favor of the government. The 3 cases that the Court has decided about detainee property all turned on the police department's problem with running out of storage space. The claim, as the Court viewed it, was that once someone is arrested and the police department inventories their property, the police department is required to hold the property forever. That's not the claim here. In this case, the property was inventoried by the police department, sent to the Cook County Jail where the sheriff held it until the prisoners were ready to leave the jail. Some of the prisoners went home. Other prisoners went to the Illinois Department of Corrections. In the class period, there were about 40,000 people that left the jail and went to the Department of Corrections. The Department of Corrections follows state law and has a policy, a written policy of which it has advised the sheriff that we will accept and hold until the prisoner leaves our custody government-issued identification.
When does the constitutional harm happen?
It happens when we consider the Fourth Amendment, which recognizes personal property, the Fifth Amendment, which recognizes all property, and the 14th Amendment, which also recognizes all property. We also have...
Is it taken under the Fourth Amendment, or does the harm happen under the Fourth Amendment at the time of the arrest?
No, the taking occurs when it's destroyed, and that's the Fifth Amendment claim. The
Just
Fourth
start
Amendment,
with the Fourth Amendment, yeah.
The Fourth Amendment claim, this court's jurisprudence has consistently said the Fourth Amendment is limited to the instantaneous taking of property or taking of a person. The Supreme Court rejected that most recently in Thompson, where they said if you're arrested and held for 4 hours, I think, in Thompson, you can then bring a Fourth Amendment malicious prosecution claim 2 years later when the criminal case is resolved in your favor, even if you're released after that 4 hours. So this court's jurisprudence limiting the Fourth Amendment to the instantaneous taking is wrong. And the court was confronted with that when a case was vacated and remanded in light of Thompson. I think that's, I can't remember the name.
But how does that affect the abandonment?
How does
that affect the abandonment rationale of all of our prior cases?
the abandonment
Because
argument...
the decisions you're referring to are statute of limitations decisions.
I'm having trouble hearing you, Judge. I'm
The
sorry.
decisions you're referring to, Manuel, et cetera, those are statute of limitations questions.
No, those are accrual.
Accrual, right,
But
for
that's
limitations purposes.
But they were accrual, but a Fourth Amendment claim it's no longer correct to say that a Fourth Amendment claim accrues at the time of the taking.
But we don't have that issue here. The rationale of our prior cases on this issue of the destruction of property by municipal officials when it's abandoned because the policy of retrieval has not been complied with.
There's another
I don't
case-
see that line of new Supreme Court cases as having any effect on the abandonment rationale of all of our prior cases.
That's not what the Fourth Circuit said when they were applying Tyler versus Hennepin County in the case that came out after briefing was done in this case called Todman versus Mayer, which is cited in the next case. That
Well, now you've shifted to Tyler. That's a takings clause case.
I'm really having trouble with it.
You've now shifted to Tyler, which is a takings clause case, not a Fourth Amendment case.
But it was it was a takings case, but it applied the abandonment argument. The municipality argued in Tyler that we told them if they don't pay their taxes, they're going to lose their property. And they didn't pay their taxes, so therefore they lost their property. They abandoned their property. And this court in Kelly Lomax and Conyers said, well, you abandoned your property because the sheriff told you you had 30 days or 45 days or 60 days to come retrieve your property. That's the same as Tyler. The principle is that you can't tell somebody you're going to forfeit your property if you don't pick it up within 60 days. That's not the same as a intelligent, knowing waiver and abandonment.
I'm still asking, though, when under the Fourth Amendment does the constitutional harm happen? Looking at, you said there's a Fourth, a Fifth, and a 14th. So just looking at the Fourth Amendment, where is the violation, or when is the violation?
In this case, it happens when the sheriff destroys the property.
So under the Fourth and the Fifth, it is when the property is destroyed.
That's right. I think there would be different damages for the Fourth Amendment and for the Fifth Amendment, but that's what we're not at that point yet. But and if we go back and look at the historical record of sheriffs who seize property, there's an understanding that they would hold on to it and take good care of it. Many of those cases are difficult to cite because they involve capturing of slaves, and it was viewed by the person who wanted to retrieve the slave that the sheriff has to take good care of my property because it will diminish in value. And there are many states that still follow this rule that the police department of a sheriff who holds property that's seized is the constructive bailee or even an involuntary bailee. But we're not pressing that in this case. In this case, we're pressing that there's no rational basis for the sheriff's policy. There's no running out of storage space like there was in, as the court viewed it, in Conyers and Kelly Lomax and Wilson versus Evanston. This is the Department of Corrections says...
But before we can get to the rational basis, we have to have either, looking at Lee, a constitutional violation, or we have to have, or there has to be some representation that state process is not available.
Well, I'm not sure if state process being available is still valid after the takings claim, which says you don't need state process when there's a taking. You just have a taking, and you could go back. That's the Nick versus Township of Scott case. But you don't have to worry about whether you've exhausted state remedies or tried to get your property back. But one of the property right cases... Do we still need a constitutional violation? The constitutional violation is, if we go look at one of the cases cited in Kelly Lomax, Phillip versus Washington Legal Foundation. That's a case which involved lawyer IOLTA accounts. And the question was, who got the interest? And that was a taking, as the Supreme Court viewed it. And they said that the taking was by the result of the state law that says you don't keep the interest. I'm not sure if I'm getting clear in all this, but our basic position is that there needs to be a rational basis before the government can seize and destroy property. And without a rational basis, adopting a forfeiture statute is arbitrary and unlawful in itself. And the forfeiture statute that the sheriff applies is contrary to Tyler versus Hennepin County. If there are no further questions, I'd like to reserve the rest of the time.
Thank you.
Thank you.
Ms. Wasserman.
May it please the court. This is a case about abandoned property. The district court properly granted summary judgment on plaintiff's due process claim because it is undisputed that plaintiff had adequate notice and opportunity to retrieve his property. The district court also did not abuse its discretion in denying class certification because plaintiff did not satisfy the requirements of Rule 23A. And as a preliminary matter, in this briefing, plaintiff only brings a substantive due process claim. I know there were some questions about the Fourth Amendment and the Takings Clause as well that come up in the next case. I'm happy to answer those questions as well, but I'm only planning to address substantive due process because those other issues have been forfeited in this case.
Before we get there, why not just ship the government IDs to the Illinois Department of Corrections?
Sure. So in this case, again, plaintiff was given, twice he signed 2 forms, property retrieval forms, understanding that his property would be destroyed if he didn't take action. So the government had no reason to think plaintiff even wanted the property. So even assuming it's, a minimal cost to ship the property, there's no reason to ship property that has been abandoned and that the government has no indication that anyone wants, which is the case here.
I guess just to drill down, why aren't government IDs transferred to the Department of Correction? What is the basis for that? What is the rational? What is the basis for it?
So I think, again, as was raised in Conyers, Kelly Lomax, there's the concept of, there being limited space to store all of this property. There's obviously some
I'm not talking about
administrative-
all of the property. I want to know why government IDs.
So again, I think the concept, this case involves government IDs, but in terms of just storing the property generally, it's not separated that way. So, while one ID in this case, doesn't take up much space, we have to think of it in terms of policies that affect the entire Cook County Department of Corrections. And again, it's not in the record in this case, but there's a policy of the Illinois Department of Corrections where detainees have the ability to get a license upon leaving the Illinois Department of Corrections. So again, I think it just comes down to the fact that unless they are told that there is some reason that the individual wants this document, there's no rationale for them to, go through the effort of transporting it.
And so the Department of Corrections has made it clear that they are willing to receive government-issued IDs. And there's some property that goes with the individual being transferred.
Correct. So they're willing to accept the property. At the time of this lawsuit, the policy wasn't to ship the property. And again, I'll just reiterate that, so there is a rational basis, of course, for the policy, but again, even before reaching rational basis, we'll just stress that here plaintiff hasn't stated a fundamental right that would even implicate substantive due process. So I think he seems to believe that, if the policy is irrational, it's necessarily constitutional, but as this court's made clear in its prior cases, first it's necessary to state a fundamental right that implicates due process. And
That's for unenumerated rights theory. This is property.
So
It's not a Glucksberg claim.
Sure. So while, this court has made clear that property is a fundamental right, abandoned property is different, and that's something that this court recognized in Kelly Lomax. So again, it's our position here that there's no dispute that the property was abandoned. Plaintiff had, 2 opportunities. He signed 2 property retrieval forms indicating that the property would be destroyed. He doesn't plead anything in his complaint stating that he made any effort to retrieve the property. In his deposition, he states that he didn't designate anyone to pick up the property. He never says that's because he couldn't do it. There's just no reason that he's given to contradict that abandonment analysis here. I can also briefly address plaintiff talks about class certification in his brief. Just briefly, defendants did not waive numerosity below. There's an entire section of the brief titled numerosity. Plaintiff also doesn't actually dispute the fact that he didn't establish numerosity. He only takes issue with the fact that the district court, he says, did its own analysis. But again, case law makes clear that even if the defendant had acquiesced to the plaintiff's arguments, the district court does not simply accept that numerosity or the other requirements of Rule 23A are established. And here, plaintiff made, as the district court said, almost no showing that numerosity was established. He submits 42 declarations, but only 2 fall in the proposed class period. The declarations, don't show that those individuals wanted IDs and weren't transferred with them. So if this court has no further questions, We ask that you affirm the decision of the district court.
Thank you.
Thank you.
Mr. Flaxman, anything in rebuttal?
I am having trouble hearing, and I tried very hard to hear what everybody was saying. I didn't hear anything, and I don't want to be misstating what I heard, but I didn't hear any explanation of what the rational basis was for not sending the government-issued ID to the IDOC. I heard something about not separated that way. If we expanded the record, it would show that the arresting agency takes the ID and puts it in a pocket inside the inventory bag, and that's sent to the jail. And the jail then takes out of the inventory bag the things that the prisoner is allowed to have, but just can't be bothered, apparently, to take out the government-issued ID and throws it away. If the state tells you, the sheriff tells you that, well, they can get a new ID. There's a policy at IDOC that lets people get new state IDs. That doesn't give somebody a new birth certificate, a new social security card, and it's not the same as having yours. It's something you have to go through. That is not, there's no reason to it. We talked a little bit about state law, but state law, as we know since Board of Regents versus Roth, is the existence of a property interest is determined by reference to existing rules or understandings that stem from an independent source, such as state law. The state law here is that IDOC will hold onto state IDs. And the sheriff still hasn't been able to articulate, in response to pretty direct questions, why he doesn't want to send those IDs to the prison. It's not enough, I submit, to say, well, he could have gotten somebody to go pick up his state ID for him. He didn't have to, he didn't want it because he didn't hire someone to go pick up his ID. He didn't have to do that. It was his. The sheriff had an obligation to hold it while he was there and to send it to IDOC when he left. We talked about class certification. That's only an issue that should be reached if you're going to reverse on the underlying issue. And I think there's no disagreement that there are 40,000 people in the class period. We produced affidavits from 42 people who, 39 said, I had state ID or government issued ID when I went to the jail. And for the sheriff to say, that's not enough to assume that there's more than 40 people out of those 40,000 who had state IDs. Well, even though there was the heading about numerosity, I think we set it out in the brief. Nothing in there speaks to state ID. That's directed at the property claim for which that's been abandoned. Thank you.
Thank you. Thanks to both counsel. The case is taken under advisement, and hold your seats because we'll call the next case, which involves the same counsel. So we'll move on to Carter versus the Cook County Sheriff. Mr. Flaxman, what's unique about this case?
Thank you, Your Honor. This case was decided on a Rule 12b6 motion to dismiss. The district judge was applying decisions in Kelly Lomax, Wilson versus Evanston, and Conyers versus Chicago. He mistakenly said that the plaintiffs were prisoners in the IDOC. I don't know where that came from, but everybody was out of custody when the case was filed. The Carter complaint squarely presents the three constitutional theories, the Fourth Amendment, Fifth Amendment, and 14th Amendment. And that's, I think we covered it before. If there are questions, I'll be glad to try to answer them.
The government in Tyler argues that the abandonment occurred before the government seized Tyler's property. And the government in this case is arguing that the abandonment occurred after the government seizure, and Carter failed to adhere to the process. Aren't these differences material between Tyler in this case?
No, I don't think they are. I think that the common thread in Tyler is that you can't infer an abandonment by creating a rule saying if you don't do something in a particular time period, you have abandoned your rights. You can't do that unless there's some compelling reason to do that, or even a rational reason to do that. Here, the sheriff just wants to get rid of the property and says, if you don't pick it up, we're going to throw it away.
Is the timing immaterial to you? The timing of the abandonment?
I would say no. And that's certainly an issue that the sheriff could try to raise as an affirmative defense if we get to that point. I don't think they raised that in summary judgment.
Question, looking at Tyler, I know that there are two cases that the Supreme Court really leaned into in explaining when there's been a takings clause violation. And it looked particularly at Nelson versus New York and the Texaco case. And in the Nelson versus New York case, as they explained in that dealing with the New York property, is that the reason why the takings clause had not been violated there is because this property right and the surplus that was available, there was a process for the property owner to come back behind, I think it was 20 days, to come back behind New York and request that surplus. And the Supreme Court talks through why Nelson is still good law after Tyler, the linchpin being that there was process available so that the property, the abandonment, I guess, that New York had declared in Nelson, there was a process for that property owner to come back and show their intent of not abandoning the property. And so because that process was in place, Nelson versus New York remains good law after Tyler. Looking here kind of at this case, and we saw similar to that in Texaco. In the Texaco case, the use of the property included either continuing to mine there or filling out that form that says, I still have an intent. And because neither one of those things were followed, Texaco is still good law. In Minnesota, in the Tyler case, what was unique was after taking the property for purposes of taxes, and there was no process for Ms. Tyler to request that her property be returned. And so you can't come back, Minnesota, and say, of course she abandoned the house because you didn't give her process. And so when we're looking at the facts of this case, and this is where I'm asking when you said Tyler kind of sets the stage and why Conyer is no longer good law, what do we do with the notion that process is still available before that property is destroyed?
Process is an opportunity, is notice and an opportunity to be heard.
Yeah.
The notice that was given to every prisoner who went to IDOC from the jail is on this waiver form, which says the IDOC will not accept this property. You have to have somebody pick it up or we're going to throw it away. That was incorrect. That was bad advice. That was just laziness from the part of the sheriff that didn't want to open these bags to take out the state ID. So and there's no impartial, there's no court to go to for your state ID to get back. That makes that makes it a viable remedy.
So the notice is inadequate.
Oh, yeah, a notice is not just inadequate, it's misleading and erroneous. And I think we actually discussed that. Thank you.
All right, thank you. Ms. Wasserman?
May it please the court. Plaintiffs failed to state a claim under the Takings Clause, the Fourth Amendment, or substantive due process. Unless there's preliminary questions, I will address each briefly.
Why don't we go to takings first? Tyler and Texaco both say that abandonment requires decades. Here we've got 45 days. Does that present a problem for the sheriff?
So I think a big distinction is dealing with real property versus the identification cards here. And again, so Tyler, the Supreme Court actually stated that the case wasn't about abandonment at all. And an important part there is that in Tyler, that case dealt with failure to pay taxes, which obviously can be due not to an intent to abandon your home, but for inability to pay. We don't have, a parallel here. Here, plaintiff doesn't allege that he was unable to, again, designate someone to pick up his property or anything like that. So I think that's a big distinction.
But to drill down on the point, though, don't we see that in Tyler, the government was arguing that the reason why Ms. Tyler's not entitled to the property right of the surplus is because she abandoned her home.
Correct. And that argument was rejected. And again, I think the Supreme Court discusses that, the forfeiture law at issue there didn't deal with use of the property at all. It just dealt with inability to pay the taxes. And that's why they reject the government's argument and conclude that the forfeiture scheme, isn't actually about abandonment. Whereas here, we are dealing with an abandonment analysis. Again, here, plaintiff has given us no reason to contradict the court's conclusion that he abandoned his property.
So you're saying this policy is not a forfeiture scheme?
So I think plaintiff here abandoned his property, even, assuming that he didn't abandon his property. I think that the policy would still be constitutional, just in the sense that it doesn't implicate these claims. Again, adequate notice is given and an adequate opportunity to get the property. Again, we're not dealing with those facts here where he's alleging anything to kind of dispute abandonment. So that's the basis of our argument. But again, he still fails to state a constitutional violation.
Is the policy a forfeiture scheme?
The policy is not a forfeiture scheme akin to Tyler. I guess the property is being destroyed if he doesn't claim it. I wouldn't characterize it as a forfeiture scheme, but I guess in a sense he's, forfeiting his property rights in the sense that he is abandoning the property. But I think it's distinct from Tyler and the other cases cited, again, because here he's, given the opportunity to retrieve the property. There's no cost at issue here. Nothing like that is being alleged. And I can move on to the Fourth Amendment if there's not further questions about the taking. Again, plaintiff has given no reason to overturn Lee and state that there should be a continuing seizure theory under the Fourth Amendment. I know he talks about the Supreme Court's decision in Thompson, which dealt with malicious prosecution. Again, that obviously it deals with people as opposed to property, but even so, the malicious prosecution analysis, the court makes clear that that analysis looks at whether or not there was probable cause to initiate an arrest, which, similar to this court in Conyers when it was explaining why Manuel did not change its analysis, that deals with the initial seizure and the legitimacy of that initial seizure. So there's nothing in Thompson that would change this court's Fourth Amendment jurisprudence. And again, I know I've covered substantive due process earlier. I'm happy to address any questions that this court might have.
What about the notice?
The misleading notice. So plaintiff states that there was false and misleading notice. It's, again, a conclusory allegation. He doesn't explain why it's false or misleading. It seems to be that he's arguing that it's false and misleading because he thinks it doesn't comply with Illinois law. But again, an attempt to enforce state law isn't sufficient to state a constitutional violation. And he's not arguing it's misleading in that he didn't understand that if he took no action, the notice would be destroyed. He seems to just think it's misleading in the sense that it contradicts Illinois law. But that's not sufficient to state a constitutional violation. And if there are no further questions, we ask that you affirm the decision of the district court.
Thank you. Mr. Flaxman, anything further? None. Thank you. Our thanks to all counsel. The case is taken under advisement. We'll move to our third case this morning. United States versus Rodriguez and Morales Rivera. The other attorney?
Yeah,
Mr. Washington's here. I saw him in the
thank you.
Okay.
Why don't you go right to the door there? Just, thanks.
We're going to wait for co-counsel.
Here he is.
There he is.
Okay. All right. Mr. Roy, you may proceed.
All right, thank you. Good morning. May it please the court, opposing counsel. My name is Michael Roy, and on behalf of appellant Hector Rodriguez, this court should vacate the sentence and remand for resentencing. Our primary argument is that Mr. Rodriguez should not have received a criminal history point for his threats conviction, which in both of his appeals ended up bumping up his guideline range. We completely admit the claim's forfeited. It's under plain error review. But I don't think that's a barrier to relief here. I do not see this case really as difficult or complicated. I admit it's technical.
Hello?
Yes.
It's very complicated.
Well,
It involves an esoteric Puerto Rican statute under which your client was
I agree it's
convicted,
esoteric.
and whether it
Yeah.
fits within that is similar to that laundry list of excluded misdemeanors for the enhancement.
I agree it's esoteric. I agree it involves a 5-part test to compare a Spanish language offense against disorderly conduct. But I would draw a distinction between complex or difficult to decide versus technical. And I think a good analogy would be this court's decision in Hagen, which was another case about comparing something under the listed offenses, found plain error in that case.
Well,
Or this court.
before you
Yeah.
launch into this argument, let's use the actual language of the doctrine, which is the error in the first instance must be plain, meaning
Right.
clear or obvious, and not subject to reasonable debate.
I agree.
How do you check all those boxes?
I don't see this as subject to reasonable debate. And I think
Even with that kind of multi-factor, sort of qualitative, substantive comparison, it's not subject to reasonable debate. Should have been clear or obvious to everybody in the district court.
I think it being multi-factored, involving a qualitative analysis, doesn't mean that the answer is debatable. I think good analogies would be, like I said, Hagen, which was the exact same issue, exact same test. It was plain, clear, and obvious in that case. Or this court's decision in United States versus Ruth, which was categorical approach about isomers of cocaine under the Illinois definition. That was plain error. Again, it was like one of the most complex types of tests that this court applies, but it was still clear or obvious.
Different because that involved comparing a federal and a state statutory definition. You can just line up the statutes. Here, this multi-factor sort of nailing Jello to the wall kind of test. How can that satisfy plain error review? Why would we decide this kind of question on plain error review?
Well, this court has decided this kind of question on plain error review before in Hagen. And I would disagree that it's quite that squishy. I don't think this is like a tort claim or something where it's super qualitative or Jello to the wall. I think it's closer to a categorical approach where it's more like a mathematical formula. You do have to go through a bunch of steps, but once you do, the answer's clear. The government's trying to create a debate by, they do a good job of making it sound complicated, but a lot of their argument relies on ignoring the 2009 amendment to the guideline, which created new tests. Their argument mostly comes from Hernandez, the Ninth Circuit's decision in Hernandez, which was a pre-amendment case applying a test that has since been abrogated. If you're looking at actual published cases comparing prior convictions to disorderly conduct, this court's case in Bravo, the Ninth Circuit's case in Grob are the ones to look at.
Bravo, those de novo review
That was word de novo review, yes. Yes. But again, I would point to Hagen as an example that this type of claim can be brought up on plain error successfully.
But I think it's difficult when we look at People versus Garcia, a Puerto Rican case that was looking at this disorderly conduct and said, when you're looking at the elements of disorderly conduct in Puerto Rico, there's A, B, and C, right? There's 3 different ways to commit this crime. And in order for you to determine whether or not it's A, B, or C, it's time, place, and manner. You also have to consider the subjective effect of the conversation or the communication on the receiver. You also have to determine the intent, right? And so there's all of these elements that the Supreme Court of Puerto Rico have said you need in order to even determine how the disorderly conduct statute in Puerto Rico is applied. And based on the record that we have in front of us to do this plain error analysis, and so it's this, the Supreme Court of Puerto Rico has said looking at the statute alone is insufficient. And so when we're comparing similarities, when we're comparing the elements, they told us we need even more than the statute.
I would say that the record does contain enough to make the comparison here. To the extent that like the facts of the underlying conduct were necessary to make the determination, I would point to this court's, excuse me, I'm looking for the case site. This court's site in McNeil, where it said that if the PSR doesn't include the information necessary to do the calculation, that goes towards plain error. That's not necessarily a barrier to finding plain error relief on appeal.
But it was more drilling down on the clear or obviousness. That threat in Puerto Rico disorderly conduct, I'm going down the plain error test, right? That it was clear and obvious to the district judge without this being objected to, that this would have been a mistake comparing Puerto Rican threat and Puerto Rican disorderly conduct. It clearly should have been exempted. And so it's getting beyond the first step. Even if we accept the argument that it was there, how was it clear or obvious? Knowing what's it required to make or to conduct that analysis under that 5-factor test.
Sure. And I would push back on one aspect of that, which is that it had to be the district court able to step in and know it. I know some of this court's case law sometimes refer to clear or obvious, meaning that the district court should have spotted it and jumped in. But the Supreme Court has made clear that this is not a grading scale for district judges. It's whether it's clear or obvious in hindsight on appeal. It doesn't have to have been clear or obvious based off the presentation to the district judge. It's just whether looking retrospectively on appeal, it's clear or obvious. That's what makes the error plain.
Do we even have information in front of us to apply the test for this guideline, which requires sort of a hybrid approach? It's not just a comparison of legal elements. It involves looking at the actual conduct and making a sort of impressionistic determination about the level of culpability, the comparable level of culpability, et cetera. Do we even know what the conduct entailed?
Yes, we do. I did attach to the reply in response to the government's argument some of the documents from the Puerto Rican conviction. This court can take judicial notice of those. But even without those documents, I would be happy to march through any of the 5 factors. I see I'm already in my rebuttal time. But there is a lot that this court can look at, and the big picture is it doesn't have to be just the same as disorderly conduct. It can also be considered less severe than disorderly conduct. And even without the court records, there's lots of hints just in the PSR that this was less severe than disorderly conduct. The minor penalty he got, a fine, the fact
Disorderly conduct, though, is a very broad statute. It can be anything from carrying a firearm outside one's clothing when you don't have a possible permit to being loud on a street corner. It's very broad.
I agree completely, and I think that cuts to our benefit because I think threats is also fairly broad, but disorderly conduct is even broader and can encompass things like throwing punches at strangers in public, which is not something you'd be prosecuted under this Puerto Rican threat statute for. So you could be prosecuted for more severe conduct for disorderly conduct under any definition, regardless if you use Puerto Rico's definition, the tribal country regulation, or one of the state laws from within the circuit. All of them allow people to be prosecuted for more severe conduct for disorderly conduct than what the threat statute considers. If there's no other questions at this time, I'll reserve the rest.
Thank you. Mr. Wasserman.
May it please the court. Good morning, Judge Brennan. Good morning, Sykes, Judge Pryor. If I may be permitted, in the short time that I have to go a little off script, I'll explain why I'd like to do that. In 2019, this court decided U.S. v. Fincher, 929 F. 3rd 501. You rejected the argument that under Apprendi and Allain, the district court was precluded from making factual findings regarding a safety valve eligibility. That was followed up by a petition for writ of cert, 19-6230, and the Supreme Court actually did something they don't do all that often in this kind of case. They asked the government to respond. They ultimately denied the petition on 3-220. Now, jump ahead to something that came up after briefing. August 20th of this year, United States versus Cameron Johnson, setting to Erlinger and to Wooden. That was the case where noted in Erlinger, the Supreme Court said, no, the different occasions question under ACCA has to go to a jury. This is what I think. I'm going to ask this court to rethink Fincher in the context of the case that I'm here on, because I think now under Wooden and under Erlinger and certainly under Johnson, the real inquiry isn't the statutory charging scheme or even the sentencing scheme. I think the Supreme Court has moved to making the most important inquiry is, are we looking into a range of facts other than the fact of a prior conviction? And if we're doing that, that's what triggers the Sixth Amendment. That's what triggers Apprendi and Allain. I know that wasn't briefed. And quite frankly, I didn't see it until I saw Cameron Johnson less than a month ago, but that led me to go back and look at Fincher and ask this court to rethink that. If there are any questions, I'll reserve my time for rebuttal.
No, thank you.
Thank you.
Mr. I'm sorry, I can never get your name right.
You're not the only one, Judge. It's Aaron Wegren.
Wegman. Okay, thank you.
So good morning, and may it please the court, Aaron Wegren on behalf of the appellee of the United States. I'm doing a little bit of double duty here this morning, so I'd like to cover both appellant's arguments. First, I'll start with Mr. Rodriguez. Specifically, the issue concerning his criminal history score and section 4A1-2C.
Can we accept the supplement?
I believe you're referring to the supplementary Puerto Rican documents that
To the reply.
To the reply brief. I think this court is within its power to take judicial notice of those documents. The government does not object to that. I would note, though, that kind of speaks to the lack of the plain error in this case. The fact that my colleague needed to go back and kind of backfill in the record in such a fashion, I think speaks to how complicated and unplain, frankly, this error is. Frankly, this error fits right into this court's precedence in describing what plain error is by explaining what it is not. This case is arcane, subtle, difficult, debatable, factually complicated. Those things are what kind of distinguishes a plain error from what we have in this case, where we have a very kind of complex legal analysis with, as the judges have noted, multifactorial analysis. And I would encourage the court to look at page 3 of the supplemental materials. If the court does decide to look at those and consider those, look at page 3 and get a sense for what actually this threat was. This was not, a run-of-the-mill, offhanded comment. This was a death threat where Mr. Rodriguez threatened his then-girlfriend at the time to burn her house down with her and her children inside of it. So while my colleague attempts to dismiss this as kind of a nothing burger, if you look at the actual record, there's this quite serious circumstances here. And frankly, I think you might also, my colleague acknowledges the forfeiture. You might even get to a waiver here. There's a reason, I believe, that this issue was not raised before Judge Stadtmuller. It didn't exactly paint his client in the best light.
Well, in the supplement, we don't have a whole lot of information about the conduct other than what he said, right?
Correct. It is, it's written in Spanish, and it is essentially the complaint and then the judgment. So it is not entirely clear, even on this supplemented appellate record, the precise factual circumstances surrounding, for instance, we don't have evidence regarding whether Mr. Rodriguez had a weapon in his hand when he made this threat, what his girlfriend had said to him to prompt it. There's a whole host of circumstances that remain unknown. I want to address the McNeil point that my colleague raised. That's a different circumstance in that case where it had to do with complying with a plea agreement and ensuring that the district court was following the plea agreement, and that was a burden that fell on the district court. Here, we're dealing with an exception to an otherwise applicable sentence where Mr. Rodriguez is the one, if you look at this court's decision in Booker, it places the burden on the defendant to show that he is entitled to that exception. That's why my colleague tries to shift the burden from his client below in terms of fleshing out the evidentiary record to the district court of its own accord to kind of dive down this rabbit hole and flesh out the record. That wasn't the district court's obligation to do a sua sponte. That was Mr. Rodriguez's obligation to present that argument in the district court as well as the evidentiary record to support it. I also want to address the Hernandez decision that we cited in our brief. Now, to make absolutely clear, the government is not encouraging this court to depart from its traditional common sense test that is always followed. It has always applied the kind of same approach that is now the Sentencing Commission adopted with application note 12A to section 4A1.2C. Government position is you look both at the categorical elements of the offenses, both the predicate offense of the defendant as well as the enumerated exception in the guidelines, but you also look at the precise factual circumstances. Now, Hernandez is a Ninth Circuit decision that predates the application notes adoption by the Sentencing Commission. The reason we cited it is because it is the most directly on point, both factually and legally, in terms of its analysis of the elements. It dealt with a predicate offense that was a threat, and it also dealt with the argument that that threat was analogous to disorderly conduct. So it's kind of directly on point on both those prongs. Now, yes, the Ninth Circuit didn't reach the full prongs of the 12A test and the analysis that this court is going to get to, but it did deal with the elements, and as Mr. Rodriguez acknowledges, the elements of the offense are still part of the current appropriate analysis. So the Ninth Circuit's analysis of the elements in that case is still appropriate persuasive authority for this court's conducting its analysis. And the key point in that case is basically distinguishing amorphous, undirected criminal conduct that is kind of makes up disorderly conduct versus the type of threat we have in this case, where it's a specific target, specific victim, very detailed threat of what is going to happen. So, while my colleague's argument kind of takes a sticks and stones approach to this, like disorderly conduct can sometimes involve physical violence, so that means it's always more serious than a threat. I think that underplays the type of damage that can be done by threats and the seriousness of the threats in this specific 2012 offense. And finally, I want to address Hagen, this court's decision from a couple years ago. I think you can distinguish that case on a number of grounds, one of which it wasn't complete forfeiture in Hagen. The defendant in the trial court had raised this 4A1-2C argument. It just a different enumerated exception. So the argument was in the ether. The parties were debating, whether it fell into an exception or not. This court, on appeal, just looked at a different exception in overturning. And so that's, it wasn't a complete forfeiture like we have in this case. Secondarily, in Hagen, you had a much more adequate record on appeal where all the circumstances surrounding the predicate offense in Illinois were known. Here we have none of that. I just want to briefly touch on the secondary argument raised by Mr. Rodriguez with respect to Judge Stadtmuller's comments at the sentencing. I don't think this court can find any fault with Judge Stadtmuller in those comments. I think they need to be read in context. Mr. Rodriguez expressed remorse at the harms that he had caused his own family members. Judge Stadtmuller, I think, was entirely appropriate for him to remind Mr. Rodriguez that his crimes had not harmed not only his family members, but also members of the broader public, and as well as the description of the harms caused by gang violence in major metropolitan areas. I mean, this was one sentence in the otherwise complete sentencing transcript. This was not an extended duration. I just don't think you can portray this as a scapegoating one defendant for all of modern society's ills, and that's reflected in the ultimate sentence of a below guideline sentence. This wasn't scapegoating in any sense of the word. Unless there's any questions with respect to Mr. Rodriguez appeals, I'll turn my attention to Mr. Morales Rivera's appeal. Firstly, I note that this is the first time we've heard anything about the Sixth Amendment or Johnson in this court. There was no supplemental briefing or anything, and I think this court, frankly, that issue has been waived by my colleague by not raising it before today. With respect to the allegations that were the argument that was actually briefed, I will acknowledge, the government acknowledges that Judge Stadtmuller made a slight misstatement of law at the sentencing hearing when he said the offense firearms enhancement was the same thing as the safety valves no firearms condition. That's technically incorrect. Not to be fair to Judge Stadtmuller, he was conducting the sentencing before this court's decision in Bingham last year that kind of drove home this distinction between the two. So he was operating in a pre-Bingham world, didn't have the benefit of that opinion, yet the government still acknowledges it was slightly incorrect. That being said, that slight incorrect statement of the law was totally harmless in this case because of Judge Stadtmuller's, one, his expressed factual finding that Mr. Morales Rivera possessed guns in connection with his offense. He can't meet the safety valve because he can't meet that one prong. And secondarily, he can't meet the final prong of the safety valve because he never provided the government with any information concerning his crimes.
Mr. Wagner, the number of defendants who are subject to the firearms enhancement who also satisfy the safety valve are going to be rare, correct?
You have to thread a little bit of a needle, Your Honor. There are particular circumstances. I think it's most pronounced when the defendant himself is not the one who possessed the firearm. It is a co-conspirator or co-defendant. That is, I think, the most salient difference between the two, as well as the burden of proof. On the safety valve, it's the defendant who bears the burden of proof, contrary to the offense enhancement, where it's the government. So it is a pretty rare circumstances where it's going to apply to one but not the other, but it can happen.
Okay.
Unless there are any further questions, I'll rest on our briefs.
Thank you.
Thank you. All right, rebuttal, Mr. Roy.
All right, thank you, Judge. I will just emphasize really quick, our view was that the supplement in the reply was not necessary to show plain error, but with those facts there, it only helps with almost every factor of the test. The government highlights the exact nature of Mr. Rodriguez's threat in Puerto Rico, which, yes, it was a criminal act, but so would have something that could be prosecuted as disorderly conduct.
When we're trying to do the comparator for disorderly conduct, what should we use? There's a variety of federal regulations that might provide for it. What should be used as the counterpoint or the comparison?
I mean, our position is that it should be Puerto Rican law, just because that's what this court has done previously, and that's how we briefed it. with our understanding of circuit law. But frankly, we're agnostic because we think we succeed under the government's preferred definition too. Unless there's any further questions, I see that I'm out of time.
Thank you.
Thank you.
Mr. Wasserman.
Thank you. The U.S. Attorney said the apparently argument was waived. What he didn't say is that it wasn't a good argument. Thanks.
Thank you.
Mr. Wasserman, thanks, Mr. Wagner.
All right. Thanks to all counsel, the case is taken under advisement, and we'll move to our fourth case this morning. United States versus Dennis. All right. Hello again, Mr. Roy.
Thank you, Judge. Good morning. I'll state again for the recording. My name is Michael Roy on behalf of appellant Larry Dennis. This court should vacate Dennis's sentence and remand for resentencing. Our primary argument is that the district court erred when applying the threat of violence enhancement because it accepted the government's assertion about what the poll camera video showed without requiring the government to actually submit the video. I want to point out, first of all, the government does not dispute in their brief that if Dennis's version of facts are true, the threat of violence enhancement would not apply. I'm not going to argue that every case involving self-defense wouldn't qualify as a threat of violence. I could see circumstances in other cases where, say, someone's self-defense is guarding their drugs, and that would be a clear connection to the crime. But in this case, his version of self-defense is that his father and uncle had beaten him, left him for dead only a few days prior. That was corroborated by the PSR, which said there was a police report about that incident. And his self-defense was about that familial dispute. It wasn't relevant conduct for his drug convictions.
There's a problem here in that there was no objection to the facts in the PSR, which included the post-arrest statement from your client about what was going on in this photo, or these two photos, which is that he was pointing a gun at a customer who shorted him on some money. And so that we accept because there was no objection to it. And that contradicts the sort of late-breaking self-defense argument that was raised at sentencing.
I agree that's our biggest problem is the post-arrest statements. I wouldn't say, though, that he completely failed to object. Candidly, trial counsel should have done a better job of stating Mr. Dennis's position. But they did raise the self-defense theory, not at the last minute. This was before the sentencing hearing. And his theory doesn't make any sense unless he's also arguing that the statements he made post-arrest were inaccurate, because he admits that he made false statements there, which could make sense if he's trying not to, rat out family members, saying that, oh yeah, I was trying to do self-defense against family members, or if he is saying that he was somehow coerced into making statements, or that the recording's inaccurate. The government could have very easily cleared this up by submitting the recording. It said in its briefing for sentencing that it had a recording of the post-arrest statements, just like the government had the full poll camera video.
Well, but once there was no objection, the government doesn't have to come forward with the proof. And that's what I meant by a late-breaking self-defense argument. There was no objection to his own statements post-arrest that were included in the PSR, explaining that this was a customer who had shorted him some money, and that's why he pulled a gun on him. And so if he was... The obligation to object to the PSR includes, his alternative version of what was going on, and an obligation to object to what the PSR was saying based on his post-arrest statements. So if there was some problem with that, the time to raise that would be in the objections to the PSR, not in a sentencing memorandum later on down the road and at sentencing.
I have two responses to that, Judge. The first is that his objection to the statements accurately characterizing the incident is baked into his entire argument about what the picture showed. But then second, the PSR recommended against applying the enhancement. So the government was objecting to the PSR to impose the enhancement based off the pictures. So this was the government who had brought it in. It was not something that would have been part of his calculation without the government's objection. So I disagree a little bit that he had to object to the PSR in order to bring in that enhancement. And I just want to point out before moving on to the alcohol condition that everything was in the government's hands to clear this up. They have the full poll camera video. It's not part of the record, so we didn't discuss the video, but it was available. The government had it, and I wouldn't be raising this argument if I thought the video would hurt him on remand. Also, it's the government describing, if the government felt the need to describe what the video showed outside of the pictures that it pasted into every single sentencing brief and even its brief on appeal, why not just show some of that other material instead of describing it without any citation? Unless the court has any questions about the sentence enhancement or the 3553 analysis and how the alleged armed robbery affected that, I would move on to the alcohol condition.
Go ahead.
Okay. So regarding the alcohol condition, the first thing I want to point out is first with the government's concession that the drug treatment condition did match the oral ruling. We have now two separate conditions in the written judgment that did not match the oral pronouncement. I think that shows more of a systematic failure in the production of the written judgment, and that weighs towards our benefit. I think that is evidence that the most likely explanation is they just mischecked the box. They made a mistake, just like they did with the drug treatment condition. Reading the court's oral ruling saying you can drink as long as you're not behind the wheel of a car when you're over .08, that you can be drunk as long as you don't commit crimes on the street while you're drunk. I think any reasonable person in Mr. Dennis's position would understand the condition being told to him being that you're allowed to be drunk, you're allowed to be over .08 as long as you don't do these extra things. And so then a written condition that says that a probation officer can show up with a breathalyzer, check him, and violate him anytime he's over .08 is not what the district judge meant to.
Well, if we read it literally instead of holistically, then he's only allowed to drink when the Bears are losing, right? Because that's what the judge said. So I think we have to read what the judge said in the context of the sentence.
I think that's what we're doing, Judge. I think the Bears example, right, it's an inclusive, not an exclusive example, right? The judge is giving a list of non-exclusive examples of what he can do. But there's nothing in it to say that, you're going to get tested, and if you're above .08, you're going to be violated. And I think that this might seem relatively minor compared to like the length of prison time, but it's something that could have a real material effect on Mr. Dennis if his probation officer is showing up during any of their visits, which they're allowed to do, and breathalyzing him constantly. He does have some alcohol history in his PSR, but the judge's concern was not that he's at home drinking, staying out of trouble, but maybe harming his liver. The concern is if he's being drunk in public, if he's committing crimes when drunk, if he's doing boisterous behavior. And while the PSR does have evidence of perhaps a drinking problem in his past, there's not evidence of him committing crimes because he's drunk.
Given the nuance that you've just laid out, you're asking for remand for the district court to revise or repronounce this condition. Is that correct?
Yeah, I think that would be the simplest way. It would be remand for the court to clarify what the actual written judgment should be. Otherwise, I think that the most straightforward interpretation is that it's meant to be a condition against public drunkenness or dangerous behavior while drunk, and that's the definition of excessive alcohol use. But if this court sees ambiguity, a remand for clarification would be fine too. I'll reserve the rest for rebuttal unless this court has questions.
Thank you. Mr. Hennessy.
Good morning, Your Honors. May it please the court. For the record, my name is Sean Hennessy, and I represent the United States. Your Honors, this court should affirm the defendant's sentence and correct the written judgment to reflect the district court's oral pronouncement of the mental health release condition. Your Honors, I'd like to start with the self-defense theory offered by the defendant in his sentencing memorandum and at the sentencing hearing. The PSR, and none of its factual statements were objected to by the defendant. This dispute was injected by counsel via his sentencing memorandum and at the sentencing hearing itself. It was an attorney proffer. A defense attorney's statements denying facts in a PSR are not evidence, and nor are they enough to create a factual issue that the district court would have to grapple with, calling into the reliability of otherwise uncontested factual statements in the PSR. Your Honors, everything in the record pointed to the government's characterization of the December 22, 2020 incident. And by that, I mean the record contained photographs of the incident itself taken from a poll camera that undisputedly showed the defendant pointing a firearm at an apparently unarmed individual right outside the house from which the defendant used to stash his drugs and his proceeds, and from which he sold his drugs.
What's the downside on releasing the video, given the dispute about who the gun may or may not have been pointed towards?
Your Honor, I do not know. The record does not reflect the decision-making by the government below, explaining why we only submitted photographs as opposed to the actual video. But what the record does reflect is sufficient to sustain the sentencing enhancement applied by the judge. In addition to the two photographs, those photographs were corroborated by the PSR's uncontested findings that the defendant made post-arrest statements. And I want to be clear, the finding was that the defendant made these post-arrest statements just over a month after the photographs of these incidents were created. And in those statements, the defendant said that the individual who approached him, depicted in those photographs, was a drug customer who had shorted him in the past, so he went into the house and got a gun. Your Honors, the making of those statements was not contested at any point in the district court. But Your Honor, I want to come back to something that the defendant said during his argument. The government does dispute where even if this court or the district court were to find that the self-defense theory was credible and was what happened here, that is not incompatible with application of the threat of violence. Your Honors, what is undisputed is that the defendant pointed a gun at an unarmed individual outside of the residence from which he was dealing drugs. Even under the defendant's self-defense theory, the police report that the defendant cited to noted that his father, and I believe it was his stepson, had assaulted and robbed him. It is totally compatible that the defendant was operating in self-defense while also preventing his proceeds or his drugs from being robbed at his stash house. And so I only note that because I don't think that the government has waived it, and multiple points in our response brief, we note that the photographs themselves are sufficient to apply this sentencing enhancement.
So in essence, what I'm hearing is that it's still, even under the self-defense theory, it's still related to the drug business.
Agreed, Your Honor. I think that is an argument that certainly remains available, and even if the district court had credited the self-defense theory, that's still consistent with applying this specific offense characteristic. Your Honor, if there are no further questions on the sentencing enhancement, I'll turn to the discretionary condition concerning the defendant's alcohol use. Your Honor, turning to this issue, the written judgment reconciles with the district court's oral pronouncement of discretionary condition 7. The district court explicitly ruled that the defendant was not to consume alcohol in excess. And in fact, what the record shows is that the probation officer, I believe, inadvertently had suggested no alcohol use by the defendant once released. The district court caught that and explicitly said it should be excessive, not any. That was the court's ruling, that the defendant must refrain from any excessive use of alcohol.
Where do you see ambiguity in the oral pronouncement?
Your Honor, to the extent there is ambiguity, that's cleared up by the written judgment, and that's drawn from this court's precedent, including United States versus Harris. But what I think the record shows is after making its ruling that the defendant was to refrain from excessive use of alcohol, the district court provided a couple examples of what excessive use could look like, which included driving drunk or committing crimes on the street. And I think a fundamental problem with the defendant's position here is that accepting the defendant's position as the accurate intention of the judge would make discretionary condition 7 superfluous with mandatory condition 1, which is that the defendant is not to commit any future state or federal crimes. If he's allowed to get drunk as long as he doesn't commit any future crimes, that's subsumed within mandatory condition 1.
She never puts this limit in place of the 0.08. And so you have this oral pronouncement and then those examples. And so I guess before, the argument that the government made is that the written judgment would control here because of ambiguity. And so if there's wiggle there, I'm wanting to hear argument as to how is there ambiguity, I guess.
And Your Honor, I don't think there is ambiguity. I think it's an even if argument. I apologize if I misstated that. But if there is ambiguity, the written judgment clears it up. And the standard for this court to employ is whether the written judgment contradicts the oral pronouncement, which it does not. Your Honors, if there is nothing further, the government asks that this court affirm the defendant's sentence and correct the mental health release condition.
One final question on that correct versus remand. You believe it's sufficient for our court to do so at this level versus a remand based upon some possible nuance?
I do, Your Honor. I think there's precedent for it, and specifically it's the Garan case, if I'm pronouncing that correctly. But in the alternative, I think that this court also could remand for the sole purpose of correcting the written judgment, although I don't think that would be required in this instance.
Thank you.
Thank you, Your Honor.
Thank you. Mr. Roy.
Thank you, Judge. I'll start out by disputing the government's position that this dispute over the enhancement was injected by the defendant. It was triggered by a government objection that the enhancement should apply. After that, the burden was on the government to establish that the enhancement should apply. This is not, Mr. Dennis had no reason before the government objected to the lack of the enhancement to quibble over what happened on the poll camera video because it didn't affect his guidelines before the government's objection. In response to the government's argument that a self-defense theory can still be a threat of violence, the key here is that it has to be relevant conduct to be part of an enhancement. It's not any threat of violence, anything that would trigger the enhancement. If he was a boxer and he threatened to punch someone in a boxing ring, no one would say that was a threat of violence, even though it very literally was. It wouldn't be considered relevant conduct. This is similar. There's nothing linking his dispute with his family to his drug sales, drug proceeds. The government suggests maybe his father was robbing him for drug proceeds, but there's nothing to support that in the record. That's just speculation. Lastly, on the alcohol condition, I agree with the government that there is no ambiguity, but I disagree on where the lack of ambiguity lies. I think there's no way to read in the transcript the sentence, nobody's going to stop you from drinking as long as you don't get behind the wheel of a car with over 0.08 blood alcohol level. I don't think anyone would hear that and understand it to mean you can never be above 0.08. That's taking out all the context of that sentence. Unless there's further questions, I'll sit down.
Thank you very much. Our thanks to all counsel. The case is taken under advisement, and we'll move to our fifth case this morning, Palermo versus Shadle. All right, Ms. Murphy.
Thank you, Your Honor, and good morning.
Good morning.
Morning.
May it please the court, I'm Siobhan Murphy, counsel for appellants Jason Palermo and Wes Murphy. We're here this morning on the question of whether the owner of a vessel that had a passenger go overboard on the navigable waters of the United States is entitled to be heard on his claim that he should be exonerated from or entitled to limitation of liability under the Limitation Act at 46 USC 30501. We submit that the district court erred in denying a forum for a proceeding under the Limitation Act based on the pleadings filed by the petitioners, by the appellants, and in treating this case as if it were controlled by the rule in Joyce versus Joyce. We respectfully submit that on a de novo review, the district court had jurisdiction over this claim, and that dismissal for failure to state a claim in the limitations complaint was erroneous as a matter of law. Reading the limitations complaint, there are multiple events and multiple actions and actors at issue. Plaintiff's theories were negligent entrustment plus. They were negligent entrustment that were incorporated into a general negligence count.
Ms. Murphy, would it be helpful for us to take a look at the plus? If we have negligent entrustment, and if we're looking here at the complaint, I'm assuming you're referring to the complaint and not the amended complaint.
I am, Your
the
Honor.
plus.
I don't disagree with the court choosing to look to the complaint and not the amended complaint. So let me talk briefly about the plus. The allegations in our complaint were that Mr. Palermo owned the Better Times II, that he was below deck at relevant times, that the vessel was seaworthy, that Lane Shadell, and I'm sorry, I mispronounced that name more than I get it right, was in an argument with his fiancée that evening, and that he acted, Lane did, in an unforeseeable way, that he went up on deck and wound up in the water, and we really don't know how he wound up in the water other than that his actions were in context of a fight and in context of threats.
And it wasn't a fight with Palermo, it was a fight with his fiancée.
It was a fight with his fiancée. So no one saw Lane Shadell go into the water. No one knows if he chose to go into the water, if he did something negligent, or if he simply fell asleep or something, which would also implicate his negligence rather than any negligence by Mr. Murphy, who was operating the vessel, or by Mr. Palermo, who owned it. But the denials that we've made in our own petition put at issue that there's no privity of knowledge, no actual negligence, in fact, but by putting at issue the lack of the privity component in our complaint, in a context of a very complex accident and rescue effort with implications of conduct by persons other than either of the defendants that could be causative of this loss.
But, and counsel, none of the claims in the state court litigation are imputed liability claims based on your client's ownership of the vessel. These are all direct negligence claims, are they not? Whether there's a factual basis for them or not is a separate issue, but I'm talking about the nature of the claims. The Act only provides limitation of liability for imputed liability claims that attach by virtue of the ownership of the vehicle. They don't protect against direct negligence claims.
So there's a lived experience of us as trial attorneys, and I would imagine of you as judges. We all know when we walk into the opening of litigation that the allegations in the complaint will often be broad and general, and these are. Fail to provide some rescue effort is part of that underlying complaint. And we also all know that we won't know within the 60 days in which we must seek the limitation or exoneration what the case will ultimately prove to be about. Both in Illinois State Court and here in federal court, liberal amendments to the pleadings are allowed. And so when we file the exoneration complaint, we allege the facts, we provide the facts that we think are going to help the court see that when the case is ultimately looked at on the facts, we will be able to establish that if there is liability proven by the plaintiff, it is nonetheless subject to limitation or exoneration.
Okay, I'm not hearing an answer to my question. None of the claims in the state litigation and nothing in your federal complaint under the Shipowners Limitation of Liability Act suggests that this litigation is about your client, imputed liability. In
I-
other words, your client's liability as the owner for somebody else's torts. And that's the only thing that the Shipowner's Liability
And on
Limitation Act applies to. It's his own negligence that's being alleged in the state case, and that you're describing and refuting in your federal complaint.
I disagree, Your Honor. If you look at the underlying complaint itself, the last of the theories expressed in that complaint is about failure to provide some unstated rescue efforts.
But that's a direct negligence claim. That's not imputed liability.
Well, like the theory.
Imputed liability is respondeat superior.
It is.
Or common carrier, which obviously we don't have here because this is a personal pleasure boat and not a common carrier boat.
And there's two things I think are really relevant to understanding that. That pleading does not explicitly state it's limited to the theory of negligent entrustment, which was the Joyce v. Joyce analysis. Because Joyce acknowledged that you have to have no possible set of facts under which protected liability could be proven in the case as it proceeds. That's what Joyce acknowledged. And they said that the plaintiff had pled only negligent entrustment, which inherently incorporates the privity concept. This is not a case that pleads only negligent entrustment. It has general terminology in an initial complaint in Cook County.
But in Joyce, that's where Chief Sykes is wanting to address here, is that which one of these don't require direct action on behalf of.
Well, Your Honor, I think that if you read the facts of the state law complaint in light of the facts in the federal court, we have the owner of the vessel below decks. And you have a series of events that occur. We are much closer in this case to some of the other authorities we've provided. And we particularly briefed the Inri Radke case. That's another one where I might be mispronouncing the name. But in that case, like in our case, you had an owner of the vessel who was not responsible as the captain at the time. She got involved later in rescue efforts. And at summary judgment, the court said there still wasn't enough clarity as to who was responsible for the loss to grant summary judgment either way on the question of protection under the Act.
I'm sorry, the case you referenced was In Re.
Give me a moment,
Sure.
Judge, I want to.
I think you're referring to
want to make sure-
Kothe, K-O-T-H.
K-O-T-H-E.
Yes.
And
Thank you.
that's a district court unpublished, non-precedential opinion. So
That's-
let's try to fit this within the, the contours of our own cases on this interesting area of admiralty law and the Supreme Court's cases. And the Supreme Court's cases make it clear that what we're talking about and what the statute is directed at is a limitation of liability for imputed liability claims, no fault
And I think
claims. These are all fault-based claims in which your client is alleged to have been at fault in a whole host of different ways. And you can test that, obviously, but they're all fault-based claims for things he either did or failed to do. Negligent omissions, mostly, is what we have in this litigation, or allegations of negligent omissions.
And-
And so that just takes this categorically outside of the Act,
And I
as the
think
Supreme
that
Court
Joyce
has
doesn't
interpreted
hold
it.
that. I think that Joyce explicitly stated it was only a case pled as negligent entrustment, specifically because negligent entrustment, the elements of that theory, incorporate the same concept as privity. Once you're talking about an owner of a boat who's not the operator of the boat, who's below deck, and who is allegedly liable for multiple different things occurring, including a situation of potential negligence by the decedent, you're no longer able, I think, to apply Iqbal or Twombly and say that there's no possible set of facts on which we would ultimately be entitled to exoneration or limitation. I see my time is up. If there are any further questions.
A couple questions. Do we have to reject Joyce to rule in your favor?
No,
Or
you
can
do not.
Joyce just stand on its own?
Joyce could stand on its own, limited to the particular pleadings that do in fact allege only negligent entrustment.
What about this Langnes abstention? Is that implicated in this case?
I don't think it is, Your Honor. But as I stand here, I would prefer to step back up and take a quick look at it and give you a more considered answer.
Thank you.
Thank you.
Thank you, Your Honor.
Mr. Terrazino.
Good morning, Your Honors. Phil Terrazino for the estate of Lane Shadle. The purpose of the Limitation of Liability Act was to encourage shipbuilding and to induce capitalists to invest money in this branch of industry. The act did so by exempting innocent ship owners from liability.
Mr. Terenzino, do you mind if we do kind of answer the question in Rakoff? I don't know if you're familiar with that case with Judge Dow. I know it's a non-presidential order.
Correct, yeah, I know that case, Your Honor.
And so does a ruling in your favor mean that in Rakoff was decided wrong?
No, it doesn't, Your Honor. And let me explain why. So the in Ray Cawthey case, that case is easily distinguishable from the case here and also the case of Joyce v. Joyce that this court ruled upon. In that case, the respondent was alleging negligent maintenance and inspection and also pre-departure negligence in its pre-departure investigation. The petitioner or the owner of the boat, again, this was a combined ownership boat, the petitioner was not present on the vessel during these acts of negligence, and that's why the court ruled there was no privity or knowledge. And here, as the district court correctly ruled, is that all the allegations of negligence against the boat owner, he was on the boat, and it's all direct negligence against the boat owner, and these negligence acts could not have happened without the boat owner's privity and knowledge. It goes to permitting the boat to go out into the waters. Permitting means active participation. Negligent entrustment going to active participation, which what is privity and knowledge and what the Joyce case was about.
Is there a problem here, though, because we've got a district court who's saying there is no subject matter jurisdiction. We've got both parties telling us there is subject matter jurisdiction. And then we have a district court who's engaging in a 12b6 analysis and whether or not a claim can be stated, yet we don't have a motion to that effect. It really is a morass when you talk about a direct reliance on Joyce and a conclusion of no subject matter jurisdiction when the pleadings to both parties say, yes, there's jurisdiction under 1333. How do we reconcile that?
Your Honor, there was a failure to state that there was no, what the court ruled was no subject matter jurisdiction, or a failure to state a claim because they don't allege lack of privity or lack of knowledge. All the allegations in plaintiff's state court complaint goes to privity and knowledge, and allegation of negligence, which the owner of the boat would have privity and knowledge. It's their direct negligence that caused my client to drown. The boat should never went out, and that was because the owner permitted the boat to go out that day.
Well, what the judge says at page 2 before the break for background, and because the Limitation Act cannot apply, comma, this case must be dismissed, colon, either because the court lacks jurisdiction or because petitioner has failed to state a claim on which relief can be granted. Respondent's motion to dismiss is therefore granted. The lack of jurisdiction part, if that's the basis for the ruling, how are we to affirm a motion to dismiss for lack of subject matter jurisdiction when both parties to the suit apparently agreed the district court had subject matter jurisdiction?
Respondent brought a motion to dismiss based on lack of subject matter jurisdiction because in this case, the Limitation of Liability Act can never apply in this case because of the allegations of state court complaint. And as the correct U.S. District Court judge stated, it's either the petitioner did or not do these things. If he did not do these things, there's no negligence, and therefore we don't need to limit liability. And if he did do these things, these allegations of negligence, then he had privy and knowledge, and therefore the act does not apply.
But if we reject the notion that the district court lacked subject matter jurisdiction, so we rely on the representations of the parties that there was subject matter jurisdiction, can we still rule in your favor, or do we have to send this back for the district court to, in the first instance, go through the analysis?
No, Your Honor, you can rule in my favor just like the court in Joyce v. Joyce did when the court in Joyce v. Joyce held that there was no subject matter jurisdiction because there is privy and knowledge, and the allegations are of direct negligence, in that case, negligent entrustment.
In Just versus Chambers, the Supreme Court held explicitly that a failure to demonstrate a lack of privity or knowledge does not divest the district court of jurisdiction. And we noted that holding in a footnote in McCarthy Brothers. So going to Judge Brennan's point, if that is the holding of the Supreme, what do we do with this 12B1 motion that was before the district court finding a lack of subject matter jurisdiction?
Yes, Your Honor, thank you. So the Limitation Act specifically states in the Act, claims subject to limitation under the Act include those of any loss, damage, or injury for any act without the privity or knowledge of the owner. Petitioner is bringing a limitation of liability, and respondent is saying there's no subject matter jurisdiction because there's no way there, in order for me to proceed, there has to be privy and knowledge based on the allegations.
The statute is not phrased in jurisdictional terms.
Mm-hmm.
That's the bottom line. This is Judge Crabb's dissent in the Joyce case, that it's not a jurisdictional dismissal, it's a merits dismissal.
And that is why U.S. District Court judge also held that the petitioner failed to state a claim that the allegations in the petitioner's complaint, they do not deny privity and knowledge. And that is why it was proper under 12b-6 under failure to state a claim.
But this was a jurisdictional dismissal by Judge Ness, right?
I believe Judge Ness ruled that no subject matter jurisdiction or failure to state a claim. I believe.
Well, it has to be one or the other.
But Your Honor,
He dismissed it for lack of subject matter jurisdiction. So it was a jurisdictional dismissal without prejudice.
correct, because of lack of privity or knowledge, Your Honor.
Right, and so our questions go to whether that was correct.
That was correct, Your Honor, because the limitation of liability can never stand because the allegations go to privity and knowledge, so there's no subject matter jurisdiction.
That's just an argument that this claim doesn't, this limitations of liability claim doesn't fall within the scope of the act. That's not an argument that the limitation of liability statute is jurisdictional. Is it a jurisdictional statute? It doesn't use the phrase jurisdiction or otherwise speak to the court's power.
Correct, but in
Jurisdiction is conferred by 1333.
Both parties have agreed on that, correct?
Your Honor, as Judge Ness correctly stated, the court cannot do nothing more than dismiss the case if the pleadings make clear that the Limitation Act cannot apply. And that is why Judge Ness correctly dismissed this case.
I think you're not grasping the nature of the questions. We understand the argument about the dismissal, the basis for the dismissal, the question is it a jurisdictional dismissal or a merits dismissal?
I believe it's both, Your Honor.
You can't have it both ways. Is this a jurisdictional statute?
I believe it's jurisdictional, Your Honor.
Do you, same question posed to Ms. Murphy with regard to the Lanyas abstention. Does this apply here? Are you familiar with that?
I am briefly familiar. I don't think it does apply.
Because?
There's a couple of ways which it can apply. First, if the value of the ship and the cargo exceeds the combined value of the claims brought, or if a single claimant brings an action against the ship owner seeking damages in excess of the limitation itself. Those would be the areas in which this abstention could apply. Do you see that applicable here?
Yes, it does, Your Honor, and it's because this is a single claimant, which it's the death of my client, and the case exceeds $165,000. So I'm
Where's the 165 come from?
the petitioner, attached to their complaint, valuable is $165,000. So I misspoke. Yes, it does apply, Your Honor, in this case.
All right, thank you very much. Your time has expired.
Thank you, everybody. Thank you,
Thank you.
judges.
Ms. Murphy, your time had expired, but I'm going to give you some extra time because there's a lot going on in this case.
I appreciate it, Your Honor. I will be brief. Your Honor, respectfully, I think that the problem with approaching this kind of case by taking the opposing parties' initial pleadings as establishing all of the theories that could be before the court under an Iqbal or Twombly analysis is it's contrary to, as I started to say before, Your Honor, the lived experience of trial lawyers. We all know that there can be broad allegations, and there are broad allegations here, in a general negligence claim that evolve. But we have to bring this kind of case under the rules very quickly.
Let me move you to the jurisdictional question. If Judge Ness is incorrect, and it's not jurisdictional, it shouldn't have been a dismissal based upon jurisdiction because both parties have agreed, we've got 1333 jurisdiction. And the Limitations Act itself is not a jurisdictional statute. What we're left with is Joyce, right? And then you've got some cases critical of Joyce since then. You've got the In re complaint of McCarthy brothers. We have subsequent case law that says that Joyce may have conflated the jurisdictional and the merits component. So we're going to have to address this conflation that existed, right? What we have before us then is in effect, a 12b6 analysis that was done without a 12b6 motion. The question is, when we're faced with that, is this an abstention circumstance? And I posed the two circumstances to Mr. Terrazino. Does this fall into that abstention question, same two categories?
I think it is a claim by a single estate that exceeds the value of the vessel. And we did establish the value of the vessel in our pleadings. I don't think it's been presented to the court as an abstention question. And so frankly, I didn't come here prepared to argue that. Mm-hmm. And in my time listening to my learned friend and to the court, I really have not analyzed, and I don't think I could honorably tell you I have an analysis to provide.
Okay. Your initial reaction was perhaps it meets one of those two criteria?
Well, my initial reaction is it meets the criteria. If it's a wrongful death claim, it will exceed the value of the boat. That it meets. The secondary question is, what are the implications of that? How would that impact the motion that raised that question? And in all truth, Your Honor, I would need time to give you that analysis. I can't do that on the fly competently.
And there's a second order series of questions about the necessity of a stipulation. If there's federal abstention and the case goes back, and the case in state court can proceed. There's a
And
necessity
here-
of a stipulation that whatever happens in state court is not res judicata on the limitations
Correct.
issues.
And that was not presented. There's been very recent interesting jurisprudence about how we're supposed to go about doing that. All of that is not present in this case. So if I have the chutzpah to speak just a bit more, I think if we look at Coriel versus Phipps, if we look at the overall jurisprudence of the Limitation Act, it wasn't intended to be administered with a tight and grudging hand. It was intended to allow us to put this issue in play, and then there will come a day when we know what the liability facts are. But we're really still not there. And I don't think it's appropriate, outside of the Joyce circumstance, which may arguably be appropriate, to take a general negligence complaint at its infancy and say there will never be a chance that this is a liability that should be immunized.
And whatever we say in this case about all of these issues that we raised from the bench will have a short shelf life because the statute has been changed. And after 2022, these boats are no longer covered.
Understood, Your Honor. But we're here on this
Understood.
case.
Got it. Thank you.
Thank you, Your Honor.
Our thanks
thank
to all
you.
counsel. The case is taken under advisement. Our last case for argument this morning is Walters versus Professional Labor Group. Mr. Norwillow, whenever you're ready.
Good morning, Your Honor.
Morning.
May it please the court, my name is Vince Norwillow. I am counsel for the appellant defendant, PLG, in this case before you today. The issue presented to the panel today is whether the travel time of the Mr. Walters and the opt-in plaintiffs in this case is compensable hours worked under the Fair Labor Standards Act. The district court erroneously ruled that it was, by what PLG will establish today through its argument, was a misapplication of the operative federal statute 29 CFR 785-39.
Under that regulation, can travel to a remote client ever be compensable time, under your reading of it?
Yes,
And how is that?
travel to a remote client is
I'm having a little difficulty picking you up. Can you just a little louder for me?
sure. Is that better?
Yes.
Okay. Travel to a remote client is compensable when the overnight travel to that remote job site is the travel time is a substitute, a replacement, something performed in lieu of work that would otherwise be performed by that employee. For example, if you have somebody who is works locally, and they work, we'll talk, because it'll come up hopefully here in a few minutes, MAC, the example that was used by the district court in their ordered, granted plaintiff's motion for summary judgment. You have MAC is hired and works 8 to 5. Monday through Friday, 40 hours a week. They drive from 7 o'clock from home, get to the job at 8, and that's their job. They prove to be proficient, and after several months, the superintendent on a Friday says, Mac, on Monday, pack a suitcase. I need you to go down 3 hours south of here and work at a different job site and get them caught up. Should take the whole week, so let me know when you're done. Monday morning, instead of driving to the local site here in Chicago, Mac drives 3 hours south, leaves her house at 7, gets there at 10. The hours from 8 to 10, if she were still here, would otherwise be performing work within the scope of her skilled trade on a job site in Chicago for the employer, earning wages. But instead of doing that, she is, at the request of the employer, traveling overnight to a remote site. So from 8 to 10, those hours are, those travel is substituting for her other duties, so she gets paid. Even though she wasn't hired to drive, she's hired to be, in this case, an electrician. Same thing on the way back. She finishes that job early, 3 o'clock. Superintendent on the site says, hey, great work, you're efficient, you've done better than I ever expected. You're done for the week, start the weekend early. Mac drives back home from 3 o'clock to 6 o'clock. From 3 to 5, she's driving from a remote location on an overnight assignment that is substituting for the work. If she were still in town, she would be working from 3 to 5 in the shop, doing her work as an electrician, because the overnight travel is substituting for those other duties during her regular work hours. She gets paid. That's always been PLG's position. It's always been a position of the court to have addressed this issue. The problem is that, you look at PLG Appendix 6, the court identified the very rationale that we're talking about here. The key to this whole case, the application of the regulation at issue, is the substituting duties rationale. The court, in its order, recognized the very specific reasoned rationale for when and why overnight travel time was compensable. Started at page 6 of the PLG appendix. The court said that the substituting sentence is a rationale for the rule. The sentence declares that travel away from home is clearly work time when it cuts across the employee's workday. And then the court asks rhetorically, why is it clearly work time when it cuts across the employee's workday? And then the court answers its own question. Because during the workday, a traveling employee is simply substituting travel for other duties. If the employee were not traveling, he or she would presumably be doing some other job-related task. That makes sense, and it explains the rule. That's always been PLG's position, as I just expressed. You're assigned to a remote overnight job, and because you're driving, you're not going to do the work you would normally do. The time you spend traveling is compensable. The problem is that the court cited that very specific, reasoned, textual rationale in the actual regulation itself, and then misapplied it to the PLG situation. The court went on to say at page 6 that every employee is perforce substituting travel for other duties when that travel occurs during a workday. Employees work during the workday. If they are not doing one thing, they are doing something else. No, that's simply wrong. The PLG, Mr. Walters and the opt-in plaintiffs weren't simply doing something else if they weren't driving to an assignment they accepted. It's a nationally mobile workforce. They work at sites designated by clients at specific times, at specific locations to perform apply a particular set of skills within a scope of a job classification. If they're not driving to get to the job site, they have no other duties. And the fallacy of the problem with the application of the court is it creates a very dangerous precedent that exposes employers in this circuit, at least in construction and in skilled trade staffing, any nationally mobile workforce staffing, to untenable liability. What the judge, perfect example is at PLG appendix page 13, talks about Mac. Says that she's hired by PLG and she's told to report to work Monday at 10 o'clock. She accepts the job and agrees. First reporting to work the first day, leaves her house at 7 o'clock, gets there at 10. According to the district court, page 13 of the appendix, Mac, before she punches in, does a safety into orientation, gets any tools, she's entitled to 2 hours pay for driving. Why? Because other employees already on the site started work at 8 o'clock. And if Mac survives past the first day, her regular schedule of employment is anticipated to be from 8 to 5, Monday through Friday. So she has to be paid for 2 hours before she even starts work. And at the end of the week, if she finishes at 3 o'clock, like in the first Mac scenario, Mac is done at 3 o'clock and the superintendent says, congratulations, that's great, you were very efficient. Your next assignment we'll figure out after the production meeting today. We'll text you whether it's going to be Monday, sometime next week, or the following Monday. Thank you. Mac drives home. According to the district court, she has to be paid. She's entitled to compensation for driving home, even though the work she was hired to perform is done. So the employer's ironic reward for
Did the
hiring
district
people.
court, though, stop the clock at the work hour, during the work hour on that travel home?
Yeah, it would-
Or does she get paid until she gets home?
According to the district court's opinion, she would get paid until the end of the normal workday driving home.
Okay.
Or any travel done, if she waited until the next morning and drove from 8 to 5, it would be compensable.
That would
It's
be compensable.
drive home while you're on the work time that you apparently had just finished, or driving there while on the work time of other people who are already there. The problem is, if you take this to its extreme, you have Mac, the third scenario. She's hired on a Friday and is told to be there on Monday at 10 o'clock. She says, okay. She applies for a job online, says she lives here in Chicago and is going to take the job 3 hours south, which she does. But at the time she has her Zoom interview on Friday for the job that she accepts, she's in Florida visiting her parents. It takes her 20 hours to drive to Chicago to start Monday at 10 o'clock. Under the district court's order, that employer now owes her 20 hours of pay for driving to work, because she's out of town, overnight, away from her home community, whether that's Florida or Illinois, 20 hours on the clock. Same thing when she's done on Friday. Superintendent says the same thing in MAC 2. Great job, you're very efficient. We'll text you after our production meeting today whether your next assignment will be a job that starts Monday, next week, or the following month.
Okay, I think we get the gist of the examples. And your argument essentially is that this regulation cannot plausibly apply to travel companies. And that may make sense as a business model matter, but we need a textual hook for that argument, that this regulation is inapplicable to travel companies that don't have a fixed place of business to evaluate the overnight travel against. I mean, I think that's the gist of your
Understood, Your
argument.
Honor, and the very textual justification is the rationale that was cited by the district court, is that where that overnight travel is substituting for other duties, it's compensable. Where that overnight travel is not substituting for other duties, you can't have an employee that works 8 to 5 locally every day, assign him somewhere else and say, well, because you're driving, you don't get paid for the day that you drive. If the driving takes the place of, is in lieu of, is a substitute for your regular daily hourly work, then you get paid. If it isn't, you don't. Otherwise, like the judge said, that makes sense. It explains the rule. PLG agrees.
Okay, thank you.
Thank you.
Mr. DeRose.
Good morning. May it please the court. Bob DeRose, and with me at council table is Shannon Dreher, and together we represent Mr. Walters and the 52 plaintiffs that are current and I think now at this point, former employees of PLG. This issue in this case is simple. Did PLG violate the FLSA by failing to pay Mr. Walters and the plaintiffs for their compensable travel time? The answer is an unequivocal yes. PLG attempts to complicate a very simple regulatory structure to gloss over the fact that they failed to pay their employees for their compensable travel time. PLG admits it's 100% a travel company. Its business model is entirely based upon them, these skilled workers being at the client's location at the time the client wants them. This isn't a temporary service. These aren't people that they could have looked for at a local location. These are people that were employed with the understanding that travel was part of their work. It's even in the record in the job descriptions, at SA 57 to SA 61. It's 100% travel. This band of brothers requires extensive travel. To answer Chief Judge Sykes' question in terms of, and also Judge Brennan's, the interpretive guidance addresses this type of work. Driving is work. And in the history of the statute, driving was work, and the Portal to Portal Act came in as an exception to, well, actually all time was work, all travel, whether it's foot travel, car travel was work. Portal to Portal Act came in and was the exception. Unfortunately, PLG in its brief is calling 785.39 the exception, when in fact the Portal to Portal Act was the exception, in that it was come out of the coal mining industry, where they said not all travel is compensable. We're going to accept normal, ordinary, daily commute travel from compensability. Then as you travel on to 1961, now comes 785.39 that says travel when it's not ordinary, when it's travel overnight, it requires an overnight stay, away from the home community, and that time cuts across the work hours, that is compensable. That is the rule, not the exception. PLG logic is flawed in two important aspects. One, it tries to use the workday definition in the Portal to Portal Act, but has yet, in its briefing or in arguments today, shown how it gets around 790.7C, which basically says the definition of the workday for the purposes of the Portal to Portal Act is only for the Portal to Portal Act. You can only use it for daily travel, daily commute travel. Now, 785.39 is the basis upon which Judge Sweeney below, based on the record that contained stipulations, uncontested facts, found there was no genuine issue of material fact that the time that Mr. Walters and the plaintiffs were traveling away from their home community, that required an overnight stay, that cut across their normal working hours, was compensable. Even at the podium, PLG uses the phrase rationale. And Judge Sweeney was pretty specific when he was talking about the substituting duties. It's not the rule. It's the rationale for the rule. When you look at 785.39, the rule is the travel away from the home community? Is it overnight? And does it cut across their normal working hours? That's the rule. The rationale is because they're traveling, because driving is work, they are substituting their duties of driving and travel for where they would otherwise be working. Then it goes on to give a description of some examples. We believe that Judge Sweeney was correct in finding that this travel, the travel described by Mr. Walters and the plaintiffs, falls squarely within 785.39 and is compensable, and that every attempt to overcomplicate this issue, to sort of mishmash the definitions of both the Portal to Portal Act and 785.39, notwithstanding, this is a clear case where this travel is compensable, and Judge Sweeney's decision should be affirmed.
The Department of Labor filed an amicus brief arguing that all of the travel time is compensable, not just the travel time during normal work hours. You're not joining that argument.
Well, we don't disagree with that argument. Our decision to only do the hours that cut across the normal work hours was a trial management decision because this was going to be tried on a representative basis. And there are 785, 40, and 41 that talk about whether you're a passenger, whether you were offered a plane ride and you drove. Because we were going to have to do it on a similarly situated basis, we chose to stick with the hours that we could prove across our case. We don't disagree with their position. It's just not what we presented to the judge.
Right, so you're not making a claim for all of
Not in this case, no.
All
That's
of the travel
particular-
time, okay.
Right. That's particular to this case, and that's why their brief, we don't disagree with it. It's just not the facts that they were presented for our case.
Right, and if you had wanted to take that position, you'd have to file a cross appeal because you'd be enlarging your recovery.
Right, and we're
essentially.
not. We're not asking for more. We are fine with Judge Sweeney's decision. We know that what he said about limiting or the suggestion that he might limit it was dicta, and we adopted the Secretary's position that we don't want that to be read as law. We want to be clear that was a trial management decision based on the fact that we had a certified class, and we want to make sure that we had representative evidence at trial.
Or a collective, it's an opt-in. It's an opt-in, not a,
I'm from the Sixth Circuit, Your Honor, under Clark. That's a bad word. So I've conditioned myself not to use collective. So
understood.
it's refreshing to be here in the Seventh Circuit and being able to use that, but not those of us who practice in the Sixth Circuit.
Got it, okay.
If
Anything
there are no
else?
other further questions,
Okay, thank you. Mr. Norwillo, you had used all your time, but if you've got something in rebuttal, I'll give you a little extra time.
Thank you. May it please the court. Simply wanted to add with regard to the Assistant Secretary's amicus brief, the identical argument for expansion of 78539 was advanced in Bassett v. TVA. It was soundly rejected. The other times it's been cited or attempt to be advanced, it was rejected by the district courts, most recently in the Diefenbach case, and all of the authority cited in the Assistant Secretary's amicus brief for support of the expansion is from pre-1961, before 78539 was promulgated. Finally, I want to wrap up with saying that the employees that were the PLG employees, opt-in plaintiffs and otherwise, were skilled trades people, carpenters, electricians, plumbers, masons. Driving was work. Now, they were not hired to drive. They were hired to use their hands and apply a skilled trade on designated jobs at designated locations that they agreed to work at. Just like the consultants in Abel versus Skybridge, just like the software technicians in the Borup case. That Eighth Circuit District Court decision and the Sixth Circuit Court of Appeals decision in Skybridge, even though it was applying the FLSA in the context of the Kentucky State Wage and Hour Act, said where you do not have the substituting duties rationale, as stated in the rule, overnight drive time is not compensable. Now we've got this district court that says otherwise, and at the end of the day, the problem is a serious one for employers, because in the MAC scenario, where you're adding 20 hours of drive time at the beginning of a shift and 20 hours of drive time at the end of the shift, artificially increasing the labor cost of a job, it's going to ultimately be expensive for employers and expensive for consumers. And finally, right now, the way PLG does it, as stated in the record, is 67 cents an hour IRS mileage reimbursement. So a 200-mile commute is $201, straight non-wage employment expense reimbursement to the employees. It costs a lot these days to take a F-250 packed with tools and pull in a trailer to drive 3 hours, 200 miles. Under the district court scenario, you'd be forcing employers, specifically PLG and others, to pay an hourly wage, even if those same employees, those same pros, were getting $30 an hour, or their overtime rate of $45 an hour, gross, less tax. They're getting less toward their employment-related expenses under the district court's rationale by 50% or more. So who winds up getting it in this case? Who gets the short end of the stick? The workers, again. Because we've got lawyers that want to create a cottage industry through some clever construction of a regulation that has never, ever, ever been applied in this scenario, as stated in Abel and Borup. Thank you, Your Honor.
One question, just sort of globally. You work in this area. Do you have a sense of what percentage of construction is handled by temp travel agencies like your client at this point? Is it getting to be like the nursing field, where travel nurses are staffing hospitals to a much greater percentage than used to be the case?
Healthcare professional staffing has ballooned, especially since COVID, for different reasons. But skilled trade construction, temporary services that provide a variable skilled trade workforce that is, like nurses say, that's PRN, on call. They take as many people as they need and whatever trades they need for as long as they need them, and they're allowed to control their labor costs rather than have people sitting with non-productive hours. So of all of these all of the temporary industry serviced by temporary agencies, construction and healthcare are 1 and 2.
And is this union or non-union?
The employers or the country?
Your company, your employees.
The PLG doesn't recognize any labor organization.
Okay.
But in terms of a number of the employees that work for PLG in a range of the different skilled trade classifications are union members. We just don't recognize We don't have a bargaining obligation with any particular labor organization.
Got it. Okay, thank you.
Thank you.
Our thanks to all counsel. The case is taken under advisement, and that concludes our calendar for today. The court will be in recess.